Hi guys, so now we're going to get to Lively's opposition to Wayfarer's motion to exclude the testimony of Michael Robbins. I'm sure we are all very much acquainted with Mr. Dr. Robbins. So this guy, he wraps me up the wrong way. Like, his deposition and his report were just... Well, I said in my last video, I think he's going to be Lively's equivalent of Dr. Spiegel. So he destroys notes, which he's not supposed to do. And that's pretty impressive given he's an attorney and should know how this works. He's opining on intimacy coordinators and nudity riders, despite the fact that he's had no recent experience at all. And if anything, actually, I think he once spoke to an intimacy coordinator, so that now makes him an expert. I just found, and his deposition, he was so aggressive and condescending and just incredibly rude. I'm not liking this guy at all. I don't even know what he's got to offer at this point, because the sexual harassment claims are out. The failure to investigate claim is out. Like, what is this guy bringing to the table? But I've had I normally get annoyed through this. Now, I haven't read it. I am going to try and keep myself in check a little bit, because this guy really is like a trigger for me. I don't know what it is about him. I really don't. Like, I'm sure he is perfectly good at his job. It's just, I don't... The deposition, especially, deposition transcripts tell me a lot. And how abrasive someone is, how dismissive they are, how evasive they are, it gives me an indication, like a bit of a picture into what this person is kind of like day to day. And I just don't get a good vibe off him at all, And I found that his report was just a lot of speculation, and nothing really of substance there that would have helped. But I read Wayfarer's Dalbert motion to exclude him and the motion in limine, so I am going to read Lively's response, and I am going to try and keep myself calm and measured and professional. Okay. It is by now well established that Miss Lively had concerns about Baldoni and Heath's conduct in connection with the film, and that she repeatedly raised those concerns during filming and after. Wayfarer insists that they fully resolved Miss Lively's concerns, and that as a result, Miss Lively's raising complaints or otherwise opposing harassing conduct could not have motivated the subsequent retaliatory campaign, nor any other retaliatory act asserted in this lawsuit. Tellingly, however, defendants seek to exclude expert testimony that bears directly on these issues. Specifically, defendants moved to bar the testimony of Michael Robbins, a seasoned human resources expert with nearly 5 decades of experience. Robbins, who has conducted more than 600 workplace investigations, opines on standard practices to prevent and correct harassment and retaliation in the workplace, including those specific to the entertainment industry. Guys, he had 2 years of entertainment industry experience. How Wayfarer failed to comply with those standard practices and its very own policies and trainings, and how retaliation for workplace harassment in the entertainment industry, where reputation is paramount, differs from retaliation in other industries. Defendants challenge Robbins as unqualified to offer his stated opinions and contend that his opinions are inadmissible. Defendants are wrong on both challenges, as further detailed below. Okay. Just to remind everyone, though, Wayfarer is quite open to their rebuttal expert and from Hulse being excluded if Robbins is excluded, because I think Wayfarer can feel that neither is really needed now at this point. But their position is that if Robbins is allowed to testify, then from Hulse should be allowed to rebut his testimony, which is fair. Okay. Also, if there's any background noise, I've got Mia in here and she's like snoring. I'm trying to keep her quiet, but what can you do? All right, background. Robbins brings nearly 5 decades of experience in workplace practices and investigations. He practiced as a labour and employment attorney for 20 years, including as managing partner of a leading entertainment law firm, and is the founder and president of, is it EXTTI? XT? I'm just going to say XT, which provides expert testimony, training, and investigation services in the employment area. As president of XT, Robbins regularly provides trainings to companies and other workplace investigators regarding best practices for conducting investigations, including for the Association of Workplace Investigators. Robbins is also a preeminent investigator of workplace harassment, discrimination, and retaliation allegations. He has supervised over 600 investigations. Robbins has been retained as an expert witness over 750 times for both plaintiffs and defendants, primarily in matters involving employers' efforts to prevent and investigate harassment and retaliation, including in cases in the entertainment industry. Robbins has served as a consent decree monitor in federal district courts, is a fellow of the College of Labour and Employment Lawyers, has served as president of major workplace investigator organizations, including AWI and the Society of Independent Workplace Investigations, is a longtime member of the executive board of the Los Angeles County Bar Association's Labor and Employment Law section, which he also previously chaired, and has taught labor and employment courses at multiple universities. Robbins has extensive experience in the entertainment industry specifically. He has advised entertainment clients as a practicing attorney and performed numerous investigations in the industry, including into harassment allegations on film and television sets that involve issues related to the performance of intimacy and the use of intimacy coordinators. In connection with his investigation work and as part of his expertise in harassment prevention, Robbins has reviewed and is familiar with the guidelines, standards, and protocols issued by SAG-AFTRA related to the use of nudity riders and intimacy coordinators in connection with film and television sets. Drawing on his vast experience, Robbins offers 3 opinions that will assist the jury in assessing Miss Lively's retaliation claim. 1. Defendants failed to follow standard practices and their own policies and procedures with respect to preventing harassment and retaliation from occurring with the film. 2. Defendants failed to follow standard practices designed to prevent harassment and retaliation from occurring, including by violating entertainment industry-specific intimacy protocols. And 3. How retaliation for workplace harassment in the entertainment industry is particularly harmful. Defendant's challenge to Robbins' first opinion fails. Robbins' first opinion is relevant to retaliation and liability for punitive damages. Defendants challenge that Robbins' first opinion was only relevant to Miss Lively's former 6th cause of action for failure to investigate, prevent, and/or remedy harassment in violation of California Government Code Section 1290. But this argument ignores the relevance of his testimony to Miss Lively's surviving claims. Robbins' first opinion regarding standard practices and policies for preventing harassment and retaliation, and Wayfarer's deviation therefrom, is plainly relevant to Miss Lively's retaliation and punitive damages claims, as well as defendants' primary defense that they engaged in only reasonably defensive measures without retaliatory motive or malice for purposes of punitive damages liability. Courts routinely accept expert testimony regarding standard workplace policies and practices and whether a defendant's actions comport with such standards and or the defendant's own policies and practices. In Mendoza, for example, the Court of Appeal recognized that expert testimony regarding numerous shortcomings in defendants' investigation of plaintiffs' harassment complaints could support an inference of retaliatory animus. There, plaintiff's expert criticized defendants' investigation on the grounds that defendants did not prepare a formal investigation plan, did not take written statements from the complainant or accused, interviewed the complainant and accused simultaneously rather than separately, and failed to interview any other witnesses before concluding the investigation and terminating plaintiff's employment. The court rejected defendant's challenge to this expert testimony, finding that the jury's charge was to determine defendant's subjective motivation and that the lack of a rigorous investigation is evidence suggesting that defendants did not value the discovery of the truth so much as a way to clean up the mess that was uncovered following the complaint. Ultimately, the court left to the jury to decide whether the expert's characterization of the investigation is accurate and whether to infer from that characterization that defendants had retaliatory animus. As in Mendoza, here Robbins' testimony regarding Wayfarer's numerous shortcomings in responding to Miss Lively and others' concerns is relevant to why defendants later launched their press and social media campaign against Miss Lively. So are they suggesting that Wayfarer retaliated against Lively because other people had concerns as to why they hadn't what? Are they suggesting that Wayfarer and their alleged shortcomings in responding to other people's concerns is the reason that Wayfarer allegedly launched this campaign, this harassment campaign against Miss Lively? I don't understand where they're going with that. It should be about Lively only. Specifically, such testimony bears on whether defendant's subsequent campaign was defensive, as they insist, or retaliatory. This is especially pertinent where, as here, defendant's primary defense has been that they had no reason to retaliate against Miss Lively because they allegedly resolved all of her concerns as of January 2024. Robbins' opinion that Wayfarer failed to comport with standard practices or its own policies to prevent harassment and retaliation bears directly on this defense. Such failure indicates that defendants were not as concerned with remedying any alleged harassing conduct or ensuring a safe workplace as they were with maintaining their own carefully curated images, so much so that he suggested that they would not conduct an investigation because he believed that it would be better not to have a written record. Robbins' first opinion is also relevant to and will assist the jury in deciding whether to find liability for punitive damages, specifically whether defendants acted with malice and or ratified tagged conduct during the retaliation campaign. Indeed, understanding how standard practices and Wayfarer's own policies dictated how Wayfarer should have responded to workplace concerns supports an inference that Wayfarer intentionally disregarded those standards to conceal concerns about its conduct, thereby fueling its later retaliatory acts. Defendant's position that Robbins' testimony was, only if ever, relevant to Miss Lively's failure to prevent, investigate, or remedy cause of action further deflates when considering that evidence of an employer's investigation is relevant in the context of punitive damages, even in the Title VII cases, under which no independent failure to prevent cause of action exists. Robbins' first opinion is not a legal conclusion, and his testimony will assist the jury, not invade its province. Robbins' first opinion that Wayfarer did not follow standard practices or its own policies and procedures is not a legal conclusion. It is permissible for an expert to opine on whether a dependent follows generally acceptable human resources practices. Such result is consistent with the very case upon which defendants rely. Nieves Villanueva, finding expert testimony concerning actual personnel policies are unobjectionable, but excluding conclusions that defendants' practices were contrary to municipal law. Consistent with Federal Rules of Evidence 704 and case law, Robbins does not offer any opinion as to whether harassment or retaliation in fact occurred, but instead explains accepted standards for responding to workplace concerns and how Wayfarers failed to comport with both these standard practices and Wayfarers' own policies and trainings. Nor does Robbins' use of terms like complaints of harassment or investigation or cites to guidance from the EEOC or the California Civil Rights Department render his opinion an inadmissible legal conclusion. To the contrary, it would call his expert opinion into question if Robbins failed to reference these topics in guidance. Indeed, myriad courts have previously permitted the expert testimony of Robbins and others experts who reference and rely on the very topics and resources defendants complain of here. Finally, Robbins' first opinion will assist the jury and is within his expertise. Defendants' reliance on Perona to argue that Robbins is unqualified to testify regarding Wayfarer's employment policies because he never worked for the company is misplaced. Defendants cherry-pick one of the few cases in which a court has excluded portions of Robbins' opinion. That case, however, related to a disability accommodation issues not relevant here, and is against the weight of authority routinely permitting opinion regarding whether a defendant employer complied with its own policies. Defendant's challenge to Robbins' second opinion fails. Robbins' second opinion is relevant to retaliation and not a legal conclusion. Robbins' second opinion on standard practices to prevent harassment and retaliation on film and television sets is plainly relevant to Miss Lively's claim that she was retaliated against following reporting harassment on a film set. Robbins' second opinion is specifically relevant to establishing Miss Lively's subjective belief of a hostile work environment on set and that Wayfarer acted with malice and retaliatory motive, as evidenced by their failure to follow standard practices generally implemented in any workplace and on film sets in particular. And as with his first opinion, Robbins' testimony with respect to SAG-AFTRA guidelines or other standards does not constitute a legal conclusion. Indeed, SAG-AFTRA is a labour union, not a legal or governing body with the right to promulgate laws or create legal rights of action. Finally, I was beginning to think that he wasn't aware of that point, but Lively has now acknowledged that, SAG-AFTRA guidelines on having an intimacy coordinator or nudity riders are not mandatory. They are advisory. So you cannot, they're not actionable if you don't follow them. If you choose not to have an intimacy coordinator on set, you are not breaking a law. So, if an actress or actor asks for one, or for specific scenes, it's advisable, and most people will, adhere to that, and Wayfarer did. So we're not quite sure what Lively was jumping up and down about, because, if we all remember her CRD, she actually insinuated there was no intimacy coordinator, full stop. And that turned out to be a lie. They did have an intimacy coordinator, and the intimacy coordinator was engaged. There's a bit of a dispute over whether the birth scene was intimacy or not, whether it required an intimacy coordinator or not. The intimacy coordinator herself is, sort of suggesting that actually no. So let's continue though. But I'm glad we finally got to the crux of that, because I was getting a bit sick of the sort of suggestion that, all these rules have been violated as if they were law, and they are not law. Robbins is qualified to offer his second opinion. Defendants next argue that Robbins is not qualified to opine that Wayfarer deviated from entertainment-specific standards to prevent harassment on film and television sets, including through the use of intimacy coordinators, nudity riders, and closed-set protocols, because Robbins is not himself a performer, entertainment executive, or intimacy coordinator, and has not personally drafted a nudity rider. This argument ignores both the nature of Robbins' opinion and expert qualification requirements. Robbins need not have been an intimacy coordinator nor drafted a nudity rider to testify as an expert on these matters. Robbins draws from his extensive investigation experience for entertainment industry clients and involving issues related to intimacy in films. The relevant guidelines, standards, and protocols issued by SAG-AFTRA, including the SAG-AFTRA Quick Guide for Scenes Involving Nudity and Simulated Sex, and the SAG-AFTRA Standards and Protocols for the Use of Intimacy Coordinators, and guidance from Laura Rickard, an experienced intimacy coordinator, educator, and academic researcher on intimacy coordination, and a founder of the intimacy discipline in the performing arts. This more than satisfies the specialized knowledge requirement of Rule 702. Robbins' second opinion is part and parcel of Robbins' overall expertise in harassment and retaliation prevention. Nudity riders, intimacy coordinators, and closed-set protocols are additional mechanisms designed to protect employees from harassment at work, and that Wayfarer failed to effectively implement. I don't know what are you talking about? They had nudity riders. Lively did not sign it. They had an intimacy coordinator. Lively would not go meet her. And they had closed-set protocols. So I'm really not seeing where Wayfarer failed. Moreover, this opinion is not an impermissible legal conclusion. SAG-AFTRA is a labour union, not a legislative body. Defendant's challenge to Robbins' third opinion fails. Defendants challenge Robbins' third opinion regarding the unique impact of retaliation in the entertainment industry on the grounds that Robbins is not qualified to offer such an opinion, that the opinion will not assist the trier of fact, and that the opinion is unreliable. First, defendants grossly mischaracterize Robbins' third opinion to argue that he is not qualified to offer it. Despite defendants' characterization, Robbins does not offer any opinion related to Miss Lively's damages or purport to quantify her reputational harm. Instead, his opinion solely posits that reputations in the entertainment industry carry a different weight and a different vulnerability due to, among other things, the level of public interest and scrutiny surrounding the industry, as well as the influence and reach of power brokers. Robbins opines, for example, that an accused's ability to impact a complaining actress's future career opportunities is more severe in the entertainment industry than, for example, at an insurance firm, in part because of the power and influence that Hollywood power players carry. Is that Hollywood power players like Ryan Reynolds? Because you can hardly say that Justin Baldoni is a Hollywood power player. But Ryan Reynolds is. Robbins is qualified to offer this expert opinion based on his decades of experience with workplace harassment and retaliation in the entertainment industry. For the same reason, defendants attack that Robbins' third opinion is not reliable because it is a personal opinion or pure advocacy. Fails. Robbins' third opinion is expert analysis based on Robbins' long-standing work in the entertainment industry, including his authorship of articles and presentations on this very topic. Friends, another guy who likes authorship. I'm just kidding. I'm just being snarky now. I know what it means in this context, but it's a buzzword. It's a lively buzzword. So I couldn't resist like the snark. Robbins' third opinion will assist the jury in determining whether defendants acted with retaliatory motive, whether defendants' acts were reasonable defensive measures, as they insist, and whether defendants acted with malice such that punitive damages are appropriate. It will also educate the jury as to the potential impact of defendants' conduct on Miss Lively's ability to obtain future work, including not only film projects but also endorsement opportunities. Robbins' third opinion is thus admissible. Indeed, defendants' challenges bear primarily on weight rather than admissibility. I'm not sure how Lyman's going to rule on that. I would like to think that he's going to exclude it, but I'm not sure. I thought Wayfarer put up the stronger argument to exclude him, and they were, more than willing to exclude their rebuttal expert, at the same time. There's a lot of testimony from this guy who I just don't see the relevance of it. Because anything where he's talking about punitive damages, etc., I feel like that is just speculation. And there's no need for, anything else, because Lively can testify and proper witnesses who can testify to her reasonable belief. I don't think that would require an expert. You just need to show that she had a reasonable basis for believing that she had been sexually harassed. That's it. And I'm not sure what this guy is going to bring to the table. I really don't, because all that testimony will come from people like, Lizzie Talbot, the intimacy coordinator. It will come from Ange Giannetti. People who were there, had the conversations. I don't think we need someone to come and, why would you bring an expert on, intimacy? No, not even an expert really, but on the protocols of SAG-AFTRA when you have got Lizzie Talbot, the intimacy coordinator, who was actually on set, is going to be one of the trial witnesses. So I don't see what this guy is going to bring, but Lyman may allow him to testify, which, is not overly common to exclude an expert witness unless, that there is, a good reason to do so. He may limit him as well. He might say, well, okay, you can testify to punitive damages, but, anything about and maybe sexual harassment to go to reasonable belief and all that. But anything about failure to investigate is out the window, because she's trying to say that in itself was retaliation. And I don't think it's necessary. And I mean, she's the one, she would just get hit with her own email saying, hey, if you do everything I tell you to do and give me everything I want, I will forego a formal HR. She's the one that said that. And she wasn't asking about, is anyone going to investigate this? This is what annoys me, right? Is she sat there for the entire strike. She was still in communication because she was asking about the dailies. At any point, did she contact anyone and say, hey, is an investigation underway? Is anyone carrying out a workplace investigation, in line with Wayfarer's policies? Did she ask that of anyone at Wayfarer? No. Did she ask that of anyone at Sony? No. And that's not her having to initiate it. That's not the same thing. But did she follow up to say, I would have expected you to have done this, under your own policy. Have you done it? Where are we at? Is it no one's contacted me to take my statement or my account? So, and, she was offered to be, when Wayfarer did initiate the workplace investigation in December 2024, after the CRD dropped. She was invited to take part in that, and she said no. She could have had an investigation through SAG-AFTRA. She could have had an investigation through her CRD, filing a complaint. One of the things they would have offered is an investigation. She would have said no. And I've already said this, but again, for those who haven't watched that video, the reason I believe that Wayfarer didn't initiate an investigation into, the workplace and into her complaints until December 2024 is because everything was fine. She had her, I'm going to forgo this after phase 1. I'm going to forgo a HR if we do all this. Wayfarer did that by Lively's own admission. Everything was fine. Okay. There was no need to unfollow him. Nothing had happened. No need to unfollow him. No need to get everyone else to do that either. There was no need to not stand with him or do interviews with him as part of the promotion as the 2 lead stars, right? Because she'd worked with him. So there was, what are you gaining by not standing with this man for promotion? You are trying to whip up the media into questioning what's going on. Is there a feud? And that's exactly what happened. She knows what she's doing. But the reason Wayfarer did not actually initiate an investigation, in my opinion, is she didn't go back to him to raise a complaint of retaliation. So the retaliation allegedly happened after the premiere. She didn't contact him again, and she did not go back and allege that, there was retaliation and did not make a complaint about it until the CRD was filed on the 20th of December, by which time, shortly after, Wayfarer instructed an external law firm to conduct an investigation into the workplace and into her harassment claims. And because she didn't want the investigation for the actual harassment incidents from phase 1, and then everything was fine for like phase 2, and then she's alleging, oh, well, there's retaliation from the start to the middle of August 2024, but she never said anything to trigger Wayfarer to think we need to do an investigation. She didn't say anything until she filed a CRD, and for some bizarre reason, a cease and desist at the same time. 3 weeks into December. So make of that what you will. But as far as I'm concerned, they didn't fail to investigate. They did. Okay. So the next video is going to be Michael Sipple, who is a certified public accountant. So his testimony kind of goes hand in hand with Richard Marks, who is the former Johnny Depp expert witness. And they're going to be talking about, everything she's lost, from lost opportunities, endorsement opportunities, acting career, blah, blah, blah. And they're going to be dealing with her damages, basically, from lost future earnings. So I'll do that video next.